Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law. Well, hello and welcome to our now 4th podcast with Maggie.
Hello.
Severine.
Hello.
And myself, unpacking the case of Joanne Properties and Moneything Capital. A recent case decided at the end of November 2020 and already discussed by us just 2 months later. Pretty brilliant, I'd say. I fear, though, that on this case, we might be in agreement on the particular facts, so I may need to use some skill then to make things a little less clear-cut, so we might be going off-piste a little bit in this episode. Let me begin with a brief outline of the facts before we jump right into the discussion. The case here involved negotiations following a compromise. Solicitors for both sides exchanged various emails headed "subject to contract." The solicitors then spoke on the 11th of July 2019, and the intendant's note recorded that it had been considered a firm offer. The email following up that conversation, however, was headed "without prejudice and subject to contract." The follow-up email again contained what the judges held to be a counter-offer, increasing the sum from £72,000 to £75,000. The reply then to that email, still headed by the way subject to contract, stated "agreed" and included a note to say that they would liaise with counsel to put a proposal to them to achieve the desired end. I'm misusing my powers here a little bit. This, by the way, contrary to the actual judge's opinion, is to me one of the deciding factors, less so the subject to contract debate. Anyway, let's get back to the facts. Joanne Properties later changed solicitors, who then claimed that there'd been no binding contract. The judge held that it was a matter to be determined objectively whether the parties had indeed entered into a legally binding contract. And Lord Lewison spent some significant time discussing the importance of the phrase "subject to contract" as a way of safeguarding against a contract coming into existence, especially for solicitors in connection with land, as one of his big arguments. He went on to say that the first instance judge, who had held that there was a contract, had seriously undervalued the force of the "subject to contract" label, holding that the parties never intended to actually enter into a contract. Now, there was some hinting in the judgment that maybe the owner of Joanne Properties had considered there to be a formal contract and the matter to have been settled. Let me therefore begin with the following question. Do we think, subjectively, the parties were actually agreed here?
Perhaps that's where we can look at the position that was taken by the High Court and the position of taken by the Court of Appeal when Lord Lewison, who looked at the position of the High Court, saying, that they seriously undervalued the subject to contract, and that effectively, I think that's probably the biggest criticism of Lord Lewison of the High Court's decision, saying that indeed they looked too much at whether the intention was that there was a contract as opposed to subject to contract. So in a way, I think that is probably the all underlying question as to on which ground, because it is indeed clear for the High Court. They did say one of the points that was picked up by Lord Justice Lewison, that the person behind Joanne Property indeed thought that the dispute had been compromised. So yes, I think that is probably the core of what we consider the basis of the decision, should it have been only looking at the fact that there was a contract, and what is the Lord Lewison appears or says that the subject to contract is just overriding everything, and it has to be taken into consideration from the start. So yes, I would say that's the core of what it is at the core of the problem here, of the legal question, I would have thought.
I'm going to sound like a politician, I think, because I'm not going to answer your question. I'm going to answer the question that I want to be asked. And I would say I don't care what the parties actually subjectively thought, because remember, it's the objectivity which is so fundamentally important for English contract law. So my answer would be, who cares? I don't care what they subjectively thought. It's how it appeared and how objectively independent from what's going on in their actual heads they thought was happening. And I suppose, to try and answer your question, perhaps one should really be asking what was in objectively or subjectively, whichever way you want to go, was in the heads of the solicitors, because they were acting and were agents for the parties. So I think it would be pretty important to stop and think about what the solicitors thought they were doing. And that's why, as Severine is saying, that label subject to contract becomes so very important, I think, given the context of legal practice. Everyone in legal practice uses that label in a particular way and knows what they're doing with that label.
Which therefore, and Lord Justice Lewison did at the end say that, solicitors of that standing surely must have known what they were doing. So, but, that brings the question. So I agree with you, Maggie, that, subjectively, who cares? Because it is indeed an objective, but that question is the thing that was arguably reached by the High Court, that objectively, there was a contract. So, but yes, I agree with you that it brings us to what is the question here: what the solicitors should have done, or are we looking at what the solicitors as agent of the parties, or are we looking at objectively defining whether there is a contract? So the subject to contract is, of course, incredibly important here.
And I suppose one has got to always remember that there is a distinction, I think, between the existence of a contract and agreement on the terms. And I think that's a point that Lord Justice Lewison is trying to make, that at first instance, there seemed to be a blurring or conflating of those two concepts. So you can, for example, have an agreement on all of the terms, everything has been nailed down, and yet there is no contract yet. And that is the classic way in which a solicitor would use the label subject to contract, because there's some other condition that is really required for a binding contract. So often in sales of land, for example, I think it would be, the money being available, the mortgage being set up. You may well have agreed all of the, the terms in the contract, and so that the mortgage arrangements wouldn't feature in that. But nevertheless, you do not want your clients to be obliged to commit to this thing without knowing that the mortgage monies are in place. So in sales of land, that would be a classic way of seeing that the contract and the terms are distinct concepts, I suppose. And you could separately have no contract yet because further terms are needed to be agreed. And that's where you've got it in parallel, if you like, no contract because the terms aren't complete. Equally, you could have a contract now, although there are some terms which the parties have decided are not important and will be agreed later. And I think many students have difficulty with that one because there seem to be some terms left outstanding. But Lord Bingham would say, well, the parties are masters of their own contractual fates. And if they're happy to go into a contract leaving some things that they considered to be minor outstanding, then fine, so be it. So long as the court can actually enforce the thing, it stands up as it is, then that's in principle not a problem. So I suppose that's one of the things that Lord Justice Lewison was concerned about, this sort of conflating of the contract and the terms.
Yes, I think that's quite clear at paragraph 34, when he said the fact that the parties are of one mind is not enough when the parties negotiate subject to contract. There must be a formal contract for inferring that the parties must have intended to expunge the qualification of subject to contract. So yes, that is very...
And he's so worried, isn't he? He's so worried about anything at Court of Appeal level. Anything that is done to this magic label, if you like, that solicitors are using day in, day out, and knowing in confidence that that's what it means, that's what's so very, very important, I think. And I think Lord Justice Lewison, being so experienced, and a property lawyer, actually, originally, landlord and tenant, he would know that. And so, don't rock the boat. The boat's not sinking. Don't start boring holes in the bottom of it and letting the water in. And you would be upsetting an awful lot of conveyancing work if you suddenly say, oh, well, it's just a label. And if the parties really were in agreement, you've got a contract. I think, there would be all sorts of problems from that.
So from what you're saying, Maggie, I wonder if I can jump in on that. The subject to contract label then seems to possibly take on a second nature, as it were. So in this context, and I think I mentioned that in the intro, the fact that there were still terms outstanding essentially justified the label of subject to contract, which means that the subjective opinion could be overridden by a subject to contract label quite nicely, I think, because there was a justification for it. I wonder if we took that away, and I know Lewison is very concerned here about keeping that certainty around that term. But if they had actually agreed on all outstanding terms, say that they had received the material back from counsel and so on and so forth, and they'd agreed, and this case had gone in the same way, I wonder whether or not then the subject to contract, because the parties clearly wouldn't have meant it anymore, could override. Now, I mean this in the sense of what we saw, for example, in terms of terms written into a contract and then terms added orally if they're in conflict, say Evans and Mazzario type situation, where they were saying you could store the goods above deck in the contract, in the written contract, and they then said in verbal on the phone, we promise we'll put them below deck. The oral term overrode the written term.
But that's quite different, isn't it? That's an argument about what the terms are.
Absolutely, yes. I'm just drawing a parallel.
And we're not actually, I don't think they are analogous. The closest analogy that I can see with this sort of problem would be the one that you're quite keen on, Tim, I think, the no oral modification idea. Yeah. That is the closest analogy that I can see here. That it's like subject to contract label. It operates in a similar sort of fashion. But the case that you're talking about is an argument about what the terms are. So that presupposes that you have a contract at this point, whereas the fundamental question in Joanne Properties is whether there is a contract or not.
I agree, but what it is going to is at a certain point, the subjective intention clearly overrides. At some point, you can see that you've gone past the point, right, where what is written is not actually meant by the parties anymore.
Well, then it's not, we can't talk about subjective intention. And that's what I was trying to say at the beginning. It's irrelevant, and I don't care what they thought of actually in their head. It is how objectively it is perceived, if you like. And so that subject to contract labelling is a very important part of that objectivity situation, if you like, or context, because the way in which the solicitors are dealing, as I said at the outset, is fundamentally couched in those terms. So even if they had agreed all of the substance, if I put it that way, but they are still persisting with the subject to contract labelling, I would say it is no different, because of the importance of that labelling, and because that is the way we have decided over the last 100 years or so, that is the safest way of preserving this certainty, if you like, that the parties can say, okay, agreed on everything, but not a contract yet.
Let me try and inject another little bit into that. Let's say they were switching these emails backwards and forwards, always in the subject line of the email, subject to contract. And on the very last bit, one of the parties says, so we are then agreed on all the terms of the contract. And the other party says, yes, we are agreed. Surely that would have to override the subject to contract.
No, I don't think so.
Yeah, I would agree with Maggie.
Subject to contract, it originated with land. So that's where its understanding and its behaviour is taken, as it were. So if you think about exchange of contracts in land, it is at that very nanosecond that there is a deal. And until that point, there is no deal. And this exchange is you might say it's a very formula ritualistic moment, but it's significant. And I think that is the importance of that labelling. And apart from that, I'd say something we've not yet talked about is the context is also very important, I think, in this case, because this is civil litigation. You're not contracting in a vacuum, if you like. You're contracting here against the background of existing civil proceedings. And in a sense, it's all very well saying, oh, well, we've got a contract, we've got a deal. But hang on, you've still got the civil proceedings round your neck. And these two things have to be brought into line. Otherwise, you have a problem. You've got to dispose of the civil proceedings in the same way, in tandem, if you like, as you're trying to wrap this up as a contract. And that makes an added complication. And I think that's what Lord Justice Lewison is trying to sort of say when he's talking about, well, the parties needed a consent order and they envisaged that that's what they were working towards. And so you do not have resolution of the civil proceedings until you've got a consent order, which is drawn up, terms agreed and signed by the solicitors and taken to the court and rubber stamped, if I can use that rude phrase, because they don't always rubber stamp it, but approved, if I use the proper language, approved by the court. And so, what's the nightmare situation? Somebody says, oh, you've got a contract, but the civil proceedings have not been disposed of properly. You don't want that. Neither party wants that.
I think it all, if I can, it's almost the protection that, you are agreed, but there is not a contract yet. So, similarly to the process of formation, there must be an agreement, which is then backed up by consideration and intention to create legal relationships. So the fact that the parties agreed on its own is not enough. So here the subject to contract, the label, as Lewison calls it, is the protection that indeed, I mean, I'm not a practicing solicitor, so Maggie, I am bowing.
No, neither am I anymore.
No, but you were, and so I am bowing to your, to your knowledge in this. Indeed, it is I can see how for solicitors it is incredibly important to have that protection that everything they say is going to be subject to contract. So it is completely agreed that, the parties may have agreed. And so I can see, Tim, what you are trying to say here, that, surely if they both agreed, it doesn't matter that, surely that is enough to say that there is a contract. But I would say here, I go back to what Lord Lewison said in paragraph 33 and 34, the fact that the parties are in mind is one thing, and yet whether they have expunged, whether they have satisfied all the formalities, for want of a better word. So I think that's how I see it. The subject to contract is here to protect perhaps the solicitors more than the parties here, to make sure that all the boxes have been ticked.
Well, you use it to protect your client's interests. And I suppose it's analogous, if you like, to the label without prejudice in civil proceedings. That's also used to try and protect your client's position, as it were. So I'm not sure it's to protect the solicitors, but it's for certainty and to protect the interests of the client. Somebody in this situation, I think, has had a change of heart, as it were, and that's why we have the dispute.
Quite, I think that's one of the fundamental elements of this case, is that one of the parties has changed their mind, changed solicitor and changed their mind on it. I want to stay a little bit. I want to probe a little bit more on the subjective, objective, and the objective part that we were talking about. So my first point was, okay, subjectively we might be able to see that they were agreed, and then there might be instances where objectively as well they are agreed, but they've left the label on. In both cases, your response was the same. So how do we square that with the case of RTS Flexible then, where they were still using the label subject to contract, but their actions, their objective actions, showed that actually they thought they were in agreement?
Well, context is not all, but it's pretty much 90%, isn't it? And in that one, it's quite different. You haven't got any litigation at the background. Wow. Yeah. This is not a contract of settlement or compromise. So you're stripping out all of these things that I'm bothered about in terms of the civil process, in terms of consent orders, in terms of having a deal which is aligned with what's happening with the civil process. None of that is at all relevant for RTS. And added to that, you've got a sort of contract which is forward-looking, if you like, rather than backward-looking, if that's not too cryptic. In other words, in RTS, people were going to do things, make things into the future. And in fact, they had actually started to do that. So that's another point of distinction. Whereas with a contract of compromise or settlement, whether or not there's litigation on foot, you're not necessarily looking backwards in a sense, because you're resolving an existing dispute. And it's not really about performance into the future. You're trying to wrap up an existing problem, as it were. So I think the Supreme Court themselves in RTS, don't they, at some point, I can't remember which of his lordships it was, who said, the context here is very important. The moral of the tale may well be, do not start work until you have finalised your contract. But if you do start work, it may not be a total disaster, in that the court could decide that, yes, the parties had reached a contract. But also in RTS, I suppose, there would have been another route to some justice, as it were, because there would have been a quantum merit claim for the value of the work that had been done.
That's exactly where I think the distinction actually lies. I know I'm answering my own question here, but and that happens more often than not.
Well, presumably you'll be happy with that answer then.
Fair, yes, I think. Well, again, what I wanted to get to was the context, really. The context is so important to these kind of decisions, and I think the context here, the compromise, the idea of the compromise. But actually, the distinction with RTS Flexible was, what else was the court going to come up with? Right. The quantum merit was going to be probably a pretty bad decision. This was a bespoke robotics installation that probably had to be finished, really, to make any commercial sense. So it probably made sense what other terms were they going to find? So in that case, I think the fact that they had started to perform and they'd started to perform on that basis, essentially the court was picking terms which they needed to pick, and those were simply the best terms that they could find. And I'm not sure that it would necessarily be decided if it were a smaller or a one-off contract or something along those lines. So I think there's a distinction. Basically, the distinction is on the facts, and probably doesn't really come down to the objective intentions that much at all.
You got a view about that, Severine?
It looks like you do. Let's put it that way. For all our listeners, we at least have the benefit of screens, so we can see faces, which you can't.
Mm-hmm. I think, somebody says it, don't they, in that judgment? They say a court is going to be very loath, very reluctant to say there is no contract when you have got halfway down the road to performing the damn thing. It's kind of like an assumption that there is this damn thing. This is... Lord Steyn might have said, the reasonable expectations of the business person. What the hell is the law doing if it decides you've performed and yet, oh no, you thought you had a contract and you've done all the work, but wise up, you haven't got a contract at all. That's a crazy situation, isn't it? So it would be, I think, unusual for a court to end up with the saying that you thought you had a contract, but you haven't, when you've performed it. And so there is pretty good evidence from that performance as to what objectively the terms were, because you have performed it and no one has argued about your performance, as it were. That to my mind, that would be a significant thing. And so RTS, I think, is a million miles, I'm afraid, away from Joanne Properties.
Quite. I'd agree with that.
The performance is always indeed yes, you did refer to Lord Steyn and the reasonable expectation of the parties, the fact that, as we traditionally tell our students, that, the courts are loath to undo something that the parties have started performing, and all the sanctity of contract and all that. But I think that the RTS was actually referred to by Lewison to show that the subject to contract clauses or impact in a wider manner than on contract for land. But I would agree with the fact that, when there is performance, and I think Lewison himself says it, that in RTS flexible, the reason why one of the elements that the subject to contract clause had been waived was indeed because of the part performance of the contract. So I would agree with Maggie that indeed they are, wide apart, but they are both illustration of what the context is in order to assess the parties' intention.
And I suppose this is a point where students would naturally feel unsettled, as it were, because we're constantly banging on about English contract law strives for predictability and certainty and clear rules, and is less bothered about justice or good faith or equitable situation. That's for the law of equity. But at the same time, we're saying, but context is so very important, which is obviously the tide going in the other direction, as it were. So there is a bit of a tension, I suppose, between that, isn't there? Certainty and predictability on the one hand, and yet being flexible enough to adjust for different contexts.
But the context is part of the objectivity, isn't it? The context gives us the full picture of what the objective intentions are. So in that sense, I don't think they necessarily go against each other that much.
Just the idea of clear rules and the certainty idea, that's one thing. And then when you talk about context being different, so thinking about the comparison between RTS and Joanne Properties, so a student might struggle to actually see, well, as you're suggesting, Tim, really, why is it different in one as opposed to the other?
When both of them were using the same label, subject to contract.
Yes.
And
they are
really
reconcilable because in RTS, if we want to summarize it and bog it down to whether there has been poor performance or not, here there hasn't.
Yes. I mean, if we were to fiddle around with the facts in Joanne Properties, nobody would be arguing probably if someone had actually transferred the £172,000 or whatever it was. How can you then turn around and say that you didn't have a contract? So to try and play with your argument, Tim, regardless of the subject to contract label, then you would have pretty good evidence that you had mutually disposed of that label, if you understand what I mean by that, by transferring the money, accepting the money.
Which goes to really what Lewison was saying in his criticism of the first instance judge, where he said that the first instance judge relied way too much on the question of whether they were agreed rather than the question of intention. And I guess the intention would be perfectly exemplified by the transfer of money, for example.
Well, I would see that as more as evidence of a mutual waiving of the subject to contract label. But it would also, I suppose, be evidence of there being a contract. So I think it comes back to the point that I was trying to make at the beginning, that there is a distinction between having an agreement and having terms agreed, if that makes sense. So a distinction between a contract and the terms.
Yes. And it suddenly, I'm thinking aloud, so please completely cut that out, Tim, if it's just, rubbish. But therefore, I'm just thinking, if Joanne Properties had sent the money, would that be an implied, because it is an acceptance of the other term, so would that be an implied acceptance?
I think it might be useful evidence that someone would use to show that the subject to contract label had been mutually put to one side, disposed of, if you like.
Okay, so one question that I have, not knowing the procedural element of subject to contract, does it need to be mutually?
Well, yes, because it's a bit like without prejudice, it's something which is there for the protection of both parties. We tend to think of waiver as being a one-sided thing, because it is a right that one of the parties has and may give it up. So waiver, in that old-fashioned use of the English words, to give something up. Quite often when we see it in contract law, as we study it with students, it is something that is a right only for one of the parties. And so you don't have this question as to, well, what of the other party? But where you've got a label like subject to contract or without prejudice, this is there to benefit both parties. And therefore you need mutual waiver. In other words, both parties have got to say, okay, let's dispose of the label now. We have now got to the contract stage. So if you think of exchange of contracts with land, which is where it started, I think, historically, you have evidence at that moment of what used to be physical exchange of documents. That moment is showing you that mutual waiver of the label. So it can't be one-sided, because like without prejudice, subject to contract is a mutual thing. It is not like giving up some conditional right that one party and only one party in a contract has. So I think that's an important feature to sort of remember about this label. It needs both parties to say, yes, okay, we are happy now, we remove the label.
In that case, the transferring of money wouldn't be enough.
Well, the acceptance of
yes,
it...
the other party would have to accept the money then, presumably.
I think that all I'm saying is the payment and receipt of money would be... I'm just playing with the facts that we don't have, but I personally, I would be arguing, if I was the advocate, or I'd be trying to argue that that would have been pretty good evidence of a mutual waiver or setting aside, if you like, of that label. We had metaphorically or metaphysically put a line through the subject to contract wording on the very last document, because it's analogous to sales of land at that moment of exchange of physical contracts. And originally you would physically move documents, you would send them in the ether or the post, as it were, or you would take them round to the other solicitor's office. It is a sort of ritualistic moment, as it were. But payment of money and receipt of that money, happily, I would say is pretty good evidence that both parties have said, yeah, okay, we take the label off now.
So why does that have to happen through performance and not through another objective way of doing it?
It could happen, I would say, in principle, in any way. But I was looking at Joanne Properties specifically, and trying to think of those facts. So I was playing with the facts, and so to try and bring it more in line with RTS flexible, if you like, because we were talking about performance. And so the only obvious instance of performance that I can think of in Joanne Properties would be someone has actually transferred this money that they were arguing about.
But if we're saying that one can do that expressly in those circumstances, wouldn't we also be able to, and don't worry, I'm trying to play a little bit here, but wouldn't we then also be able to do that impliedly?
Well, it's just yes, indeed. People don't have to say, here is the money I am now performing, please remove the label. That might have been said, but all I'm saying is it's an inference, or it's implicit that is what you meant. And coming back to the objectivity idea, standing back from the parties, that is, I would say, what a court would conceivably conclude, that by the performance, the transfer of money under the last terms that were being discussed, the parties had to the outside world and to one another indicated that that's okay, this is now a contract, and we remove the label.
So why can't we apply that into the word agreed?
Because you haven't disposed of the labelling and you haven't performed. All you've done is you've said agreed. So this comes back to my argument about there being a difference between the existence of a contract and the existence of agreement on terms. And come back to sales of lands where subject to contract started, you might have agreed every term of your contract of sale, you buying number 12A, the bungalow in Dawlish, you might have agreed everything that you needed to with the seller and the purchaser in that setting, yet there is still something that you know you want to be in place before you want to commit your clients to a binding contract. And that's often, as I was saying right at the beginning, the availability of mortgage monies. So just simply saying, agreed, I agree this is got the sum's going to be, this is the property, this is who it's going to be transferred to, this is, I don't know, all of the detail of the conveyance might be agreed. And that's just the sort of thing that was happening in Joanne Properties. Yet, no contract yet.
The one way I would try to phrase it differently, agreed is not an unequivocal, or is not as unequivocal as performance. I say that's how we can make the difference. We can understand the difference.
Well, I think I would come back to the context and Lord Justice Lewison saying solicitors use the word agreed, meaning we are talking about the terms.
So wouldn't it be more accurate to say that actually agreed then?
No, that's why
it's implied in the terminology agreed that it's not full agreement.
It's agreement on the terms, but not agreement on the existence of the contract.
Which does actually confirm what Lord Lewison was saying. In other words, it goes to the question of intention, not so much whether they were saying they were agreed.
Yeah.
I just think you need to sort of bear in mind, what are you agreeing? When you use the word agreed, what is it in that context that objectively we are concluding the parties have agreed upon? And I agree with you, Severine. If what you are saying is the word agreement is naturally ambiguous as a word that is used in ordinary English, and we, even with students, we kind of like tend to use agreement almost like as a synonym for contract. And we probably shouldn't, because this is what I'm banging on about, really, that contract is a particular concept which only a pedantic lawyer is probably bothered about. But look at the context of Joanne Properties. These are pedantic lawyers making the correspondence. They use the word agreed, meaning the terms. And because they have retained this label subject to contract, they are meaning agreed on terms, but not agreed as to a contract. Do you see what I'm getting at?
Does the label subject to contract in this case actually matter that much?
Yes, I think it does.
Because if we were to say, you know, considering the context and the civil procedure rules and everything else that goes around it, wouldn't it be implied anyway that even if they said agreed, they only meant the terms, not that they have a contract?
No, but therefore it all boils down to whether they have waived the subject to contract. And here the term is the in a way, the ultimate protection until that has been either waived by an unequivocal act, which can be either performance in RTS or any other objectively defined by the court. Therefore, that is the ultimate protection. Until and unless that goes, the parties are in one's mind, but there is no contract.
I mean, you're
No, sorry, I was going the other way. I was going the other way with that argument. Was the idea was that actually the subject to contract label wasn't actually that important for it to be subject to contract, because it was always implied that the word agreed was only agreed as to the terms rather than that they were actually in a contract.
Well, I think there are two things, aren't there? But given the context of this with the litigation, and given the important correspondence, I think there are two very strong indicators here that there was no final contract. The first is, as we've been going on about, the labelling subject to contract. And the second one, and I would say equally important to that in the context, is the correspondence that talked about a consent order.
Yes.
And that transferred what was labelled a draft consent order. And Lord Justice Lewison, I don't know the paragraph, but he picked this out. It was a Word document. And the author of it said it's set up so that we can do tracked changes. And if you're talking about a draft consent order, naturally you haven't yet got a consent order. And therefore that's another good, pretty strong indicator that you haven't got a contract yet. If what is very important in this particular setting is that you do not have resolution of a contract, irrespective of the litigation, without at the same time the litigation being happily resolved. Those two need to be aligned, otherwise some client is in a bad position.
And that to me,
and I think those two things together.
I think that's what I was saying at the beginning as well, that is actually the fact that to me was a deciding point in this case, less so the label subject to contract and much more so the fact that they hadn't actually agreed on all terms and therefore there can't be an intention, at least from the solicitor's point of view. What subjectively the actual client of the solicitor thought is probably pretty irrelevant.
But, you could have a situation where you have, say, just playing with the facts, you have a consent order which is still labelled draft, because it's not yet gone to the court, and yet it has been signed and dated by both solicitors. You then might have a particular problem if the court says, no, I can't approve that consent order. It's defective in some way. And sometimes the court does do that. So the solicitors thought that they had done a pretty good job with the consent order, but when it got to the court refused.
But wouldn't that be something like a condition precedent rather than anything else? In other words, this contract won't come into existence unless the court is going to let us. Would that really have to be solved via intentional formation, as it were?
Well, I think it's along the same lines, isn't it, as the subject to contract idea. There's this notion of an agreement is predicated, conditional on the court approving it. So even though you've got both parties having signed the thing, you may well be trying to argue that there is no final contract until that moment of the court seal going on the document itself.
No, I think the two are quite different, because in the condition precedent scenario, the contract will come into existence if the court rubber stamps it, as it were, regardless of whether in the meantime the parties have changed their mind. Whereas presumably in the kind of scenario we have now, the parties would be able to go back on it even if they had, say, agreed, because it's still subject to contract. So the basis is different, I would say. Maggie's not happy with that. I'm sorry. What have I done?
I'm not sure I understand your point. Try that again.
So if we have the situation that there's a condition precedent to the contract, so we agree that I will pay you back £500 once my salary arrives, right? The salary arriving is the condition precedent. Once that is fulfilled, I have to pay. The same would be here, is that they enter into a contract subject to the court rubber stamping it. In both cases, we have a contract. We wouldn't be able to back out of it, but the court still has to rubber stamp it.
Well, where are you going with that contract? What is it? How do you enforce it? What content does it have if it doesn't come into being unless and until the court approves it? I don't see what existence it has until that moment of court approval.
It still exists.
What do you do with it? What value does it have? How is it enforced?
Well, you don't have very much. You don't have very much value until that event happens.
I guess what are you trying to say that with a condition precedent, so if we go to the example that you've just said, as soon as the condition precedent is satisfied, there is a contract, and therefore the other party can enforce it and force you to pay if you refuse. Whilst with a subject to contract, until and unless the court rubber stamps it, A, the parties can change their mind, and B, it cannot be acted upon.
That is yes, bang on, yes, yeah. That's exactly what I was... Sorry, yes.
Why there is indeed a distinction. The subject to contract, I would say, therefore, is an added, the best protection, because until and unless that happens, there is no enforceable contract. Whilst with a condition precedent, when the condition is satisfied, then the contract is enforceable, and if breached, can be acted upon by the victim of the breach.
And that is how I would distinguish between the cases of the parties have agreed and signed both of the documents, but they are both under the understanding that the court has to now rubber stamp it. In other words, in that case, there could be an agreement. Whereas in the subject to contract, up until that point, there's nothing. So the signed document would make quite a significant difference.
I suppose you need to keep distinct that the civil process and the consent order once approved by the court, irrespective of anything that might be happening contractually, is itself enforceable as an order of the court.
Yes.
And it has absolutely nothing to do with contract at that point. It is merely being enforced by the court. Or it gives you the right as the party to go to the court and say, please help me enforce that, because it has a separate existence and a separate power by virtue of the court rules. So this becomes more complex, because when you're talking about a consent order, you're talking about the enforceability of something that is purely down to the civil procedure rules and the court's powers, and it might not have anything to do with a contract. Whereas what you were also talking about is the label subject to contract, which is something that is purely used in a contractual setting. So in Joanne Properties, you have two things that are running in parallel. And I think actually Lord Justice Lewison uses that word because he says, look, there's the CPR Part 36, there's the offers to settle and the consent order. That is controlled and administered and subject to its own rules that are purely court rules. So the CPR as we would know them now. And then in parallel, we have here an argument which is purely contract, is to do you have a contract or not? And that, so there are different branches of law, if you like, that in this case have just come along one beside the other, as it were. Now, that the nightmare situation, as I was saying a few minutes ago, is where you have a divergence in conclusion between those two parallel lines. What you don't want is a contract which is enforceable so far as contract law is concerned, and yet you do not have a consent order, which is in a civil procedure thing, which is in a line with that. Is that related to what you were saying, or some other total different point? I'm not entirely sure what your point was.
That always makes good for.
It's my no. It's. I'm sure it's my failing. Not,
no.
Not
I get the
yours.
well. I get the feeling I did a really bad job at explaining it. Séverine did a much better job at that.
Well, I'm not sure I got it even then. So, so it must be my fault. I am quite prepared to take responsibility.
I think where we might have gone off course is that I was talking purely about the contractual side and the track changes document and the fact that it doesn't matter that it might be contingent on an approval elsewhere for there to actually be a contract, because it may lay somewhere else. Whereas when we're talking about, and this is going really to what Lord Lewison was saying about the question of intention. The question of intention can sometimes be settled even though it's dependent on something else, which would just be solved by a different area of contract law, which would be condition precedent. That was my thought. I mean, whether that actually makes sense, I don't really know, because I just came up with it spur of the moment as I was listening to what you were saying. So
no, but I think the point of, to help there is a distinction between a condition precedent and a subject to contract, and I think that's what we said. And on that, your question was valid, because indeed there are consequences. Once all it needs for a condition precedent to have effectively to be binding and to be legally enforceable if breached is that it happens. If it doesn't, then there might. If it doesn't happen, then arguably there is no contract either. But the processes are two different things, and I think that's important.
I accept that in principle. Yeah. Yes.
I think that's as good as I'm going to ever get. I'd like this moment recorded. I'm so glad the recording's working. So I think we got quite far actually in our discussion today by modifying the facts a little. We've done some harm, I think, to Joanne Properties as a case by altering the facts as we went through. I was particularly interested actually in this whole applied removal of the subject to contract label. But I do think that time is probably running out. So as always, the question, or I'll formulate it differently because I know we're pretty much all agreed on the judgment itself. Is there anything we think that Lord Lewison should have addressed in his judgment? Would be my final question before we all disperse.
That sounds like a question which is pregnant with an answer. That means you have found something that you think he's missed.
Not necessarily. I thought he was ever so slightly over-reliant on the subject to contract label. And I think that is in part what we were discussing. I would have liked to see a little bit more on the whole idea of the question and subjective-objective agreement.
I don't think he wants to rock any boat there, as I said. This is a very important labelling process and system,
Yes.
which everybody knows in legal practice, and he would not want to be damaging that one.
So how would we summarise this case then in just a few words?
Go on, Severine, have you got a neat summary?
I was trying to think, oh God, only summarising it in a few words, and then I saw your face, Maggie, and I thought, I think we're both a bit stunned by your question, Tim.
I do apologise. It wasn't in the notes, so...
I think Lord Justice Lewison got it right. I'm sure he'd be able to sleep at night knowing that Mrs. Hemsworth thinks he got it right.
Well, I think he got it right too.
Then he will be sleeping very soundly then.
But who are we to cast judgment?
Well,
or not just...
My tongue is firmly in my cheek at this point, you know. Who are we? Yeah, it's true. It's true.
Absolutely. And on that bombshell, I think we can leave it there. Thank you very much for listening, and we'll be back with a new episode in just a few weeks. Thank you very much. Bye.
Bye. Bye.